name's John Zimmerman, and I'm running for this position out of the concern that the Johnson County criminal justice system pulls way too many things into the system that shouldn't be in the criminal justice system, and that both has to do with cases of all kinds that should be screened out, and a lot of petty things that get pulled into the system. Part of the job of the prosecutor, and I should say that the way the county attorney's office is set up is that there are a dozen or so assistant county attorneys who are lawyers who also work in the office. And so, like when Janet was describing these different jobs that she's had, there are different positions in the office, and so the county attorney is the person who is in charge of the office. And part of the job of the county attorney and the prosecutors under them is to screen out cases that should not be in the system. I printed off before this meeting the standards by the Iowa County Attorneys Association. So let me pass these around here, so you all can pass these around. And just point out a couple things in it. That, as it says at the top, the first line, the county attorney and the assistant county attorneys are the chief law enforcement officials of the county. County attorney is responsible for the direction and control of the prosecutorial function, and the primary responsibility of the prosecutor is to seek and obtain justice. And I want to emphasize that because I came to law school later in life, and one thing that I discovered in law school is that there is a lot of study of law, not a lot of discussion of justice, right? And so you can end up being, through your training, sort of legalistic in a bad sense. Can we get a conviction for this? Are the elements of the crime met? As opposed to stepping back and asking the question, is this just? Should this be in the system in the first place? And you can see here that if you turn to the second page, Standard 2 is about prosecutorial discretion. I think every prosecutor who's honest will say that they don't have any intention of prosecuting every violation of law in their jurisdiction. For one thing, that would be impossible, right? So, for example, in a lot of the country, until 2005, not in Iowa, fortunately, there were anti-sodomy laws, which meant that it was illegal for two men to have sex with each other. And there were lots of openly gay men in places like Texas and Georgia, and prosecutors didn't go around prosecuting them under sodomy laws, even though they admitted to being sexually active and gay. So I think that's an example of how any honest prosecutor would say, all right, so we don't intend to prosecute every case that we could get a conviction for, but instead we have to select. There are limited resources in the system. One of my commitments in this race is to not prosecute some of the petty things that pull people in. And two that I've put a lot of emphasis on are public intoxication and marijuana for personal use. So there are about 140,000 people in Johnson County. About how many of those people would you guess today would be guilty of either possession of marijuana or paraphernalia that's been used to smoke marijuana? What's your guess?
20%.
20%? So that would be 30,000 people? 25, something like that, 25,000 people? Right. So if you arrested everybody who's guilty, whatever the percentage is, let's say it's 10,000 people. How many people does Carver Hawkeye see? If you arrested everybody today, at this moment, who is guilty of violating that law, you could fill the basketball stadium. And that would, of course, be impossible. So instead, it's the few people who happen to get searched who get arrested. Almost nobody who gets charged with marijuana possession is just walking down the street smoking a joint. Instead, it's someone who is stopped and either their person is searched, or their car is searched, or their home is searched. And who do the cops choose to search? Who here has ever been searched by a police officer? Okay, a few of us, right? It tends to be, I haven't been, I've never been searched. It tends to be folks who are poor and of color, and often folks who are younger. And so, not surprisingly, the system is full of folks who fit those categories who get charged with possession of marijuana. Now, studies show that black and white people smoke pot at about the same rate, but nationally, a black person is 4 times as likely to be arrested for it. In Johnson County, it's 7.77 times more likely. So we are about twice as bad as national in the likelihood of a person of color being the one being arrested for prosecution of marijuana. Public intox is another one. Now, so we have, as you may know, a bar district right next to the University of Iowa. Does anybody know what the definition is of public intoxication in Iowa? It's, and this is a paraphrase, more or less, being or simulating intoxication in public. It's pretty broad, right? And so if you look at the Penn Mall on a weekend night, it's like public intoxication, right? And so it's a few people who annoy the police. I mean, just today, somebody was telling me that they were in a situation where they saw 3 young guys in the Penn Mall. Cops came up and told them to freeze and searched them because they were looking for 3 guys. Apparently the description was 3 black guys, and they're black. 3 African-American guys on the Penn Mall. So these were 3 African-American guys in the Penn Mall. Turned out they weren't the guys they were looking for. My friend kind of berated the cops a little bit for it and said, really? So you stopped these guys because they were 3 black guys on the Penn Mall and you treated them like that? And the cop said, we could arrest you right now for public intoxication. And she had had a couple drinks at a live show. And so it's a tool that the police can use to arrest anybody who's had more than 1 drink, more or less. And so, you know, both with marijuana possession and with public intox, these are laws that when they're used so selectively, there's something wrong with the law. And when everyone thinks it would be ridiculous to arrest everyone and prosecute everyone who is guilty of it, there's something wrong with the law. It's why a lot of University of Iowa students graduate with criminal records. It's why it's part of the reason why police here are so aggressive at searching people of color, because there are federal programs that give money to police departments for fighting the drug war. And so they show that they've made drug arrests. And so they search people aggressively. And so a lot of the reason that people of color in this community feel sort of besieged and targeted by law enforcement is because law enforcement is trying to get drug arrests. And so if we stop prosecuting some of the more petty arrests like that, the police will stop arresting people. They're not going to arrest people that are immediately going to be turned loose because the prosecutor won't prosecute them. And so we'll end up with a community in which, you know, the police go back to what their purpose should be, which is protecting people, serving people, not looking for reasons to arrest people. Let me point out, this is standard 2.2 on the sheet that I handed out. It says, the prosecutor should utilize his or her discretion in screening to eliminate those cases from the criminal justice system in which prosecution is not justified. This is from the Iowa County Attorneys Association. Among the factors to be considered are, number 2, I'll point out, undue hardship to the accused. Number 3, excessive cost of prosecution in relation to the seriousness of the offense. And it's not on here, but it says any mitigating circumstances, so that's sort of the catch-all at the bottom. I would add charges that would seem to be used in a racially disparate way. So that's another reason to drop charges. That if there's a charge that lots of people are guilty of, but it's mostly people of color who get charged for it, that's a problem. And that's a reason to cast doubt on whether to prosecute those kind of charges. Another commitment that I have is for cases in which arrests seem to have stemmed from racially motivated stop, from racial profiling because of the person's skin color, is that you look at the police report afterwards, get a sense of what happened, and if you ask the question, would a white person have been stopped and searched in this situation? And if the answer is probably not, you don't press charges in the case. You dismiss the case. That's how you get the police to stop making these kind of arrests. And there are plenty of cases. So the county attorney has mentioned her experience, and my experience in the criminal justice system, is much less. But just in this past year in Johnson County, I was working in the law school clinic representing clients, and there are routinely cases that you're like, really? Why did they stop this person? And it's even like a joke, like driving while barred, driving while black. Oh, they stopped him. Why did they stop this person in the first place? And so for those kind of cases, right now, the police have no incentive to stop making those sort of arrests. But if those cases are dismissed, if the officers who seem to be making arrests of folks because of their skin color are noted, and it's like, oh, these names keep showing up, those will stop, because no one will want to be on that list. Let me just throw out a couple other things real quick. A little bit about my background. So before coming to law school, I did various things, but mostly served as a Mennonite pastor, including most recently in Mount Pleasant, which is an hour south of them. And in that role, I was sort of an unconventional pastor, connection with a lot of marginalized folks, and spent a lot more time in jails and in prisons than in a suit and tie. And I saw a lot of folks who seemed to have gotten really bad outcomes in the criminal justice system, mostly because they were poor. And it was that frustration that led me to come to law school in midlife. And I'm talking about both victims of crime and defendants. And so, part of why I came to law school is to try to do what I could to be part of creating a criminal justice system that treats everyone as an equal part of the community, instead of really coming down hard at folks who are poor, and so that they get a very different sense of justice. Let me close by mentioning one example of this. In the Johnson County Jail, which the county attorney just talked about, there are a lot of people in there. Most of those people, usually around 3/4, are there pre-trial, which means they still have a presumption of innocence. So they've been arrested by the police. They haven't had a chance to challenge the evidence. They haven't had a chance to put up a defense. But bond is put on them. And so, if I would get arrested and there would be $10,000 bond, I'd come up with some way, one way or another, through a bonding agency or directly, to get out of jail. I'm not going to sit, if you're George Zimmerman, who was accused of shooting Trayvon Martin, or did shoot Trayvon Martin, was charged with second-degree murder, he came up with $100,000 to get out of jail before trial. But if you're poor, $1,000 might as well be $1 million, right? And so you sit in jail before trial, based solely on a police officer's decision to arrest you. What often happens is that if it's not a real serious charge, that after you're in for a certain amount of time, one of the prosecutors comes to your lawyer and says, well, they can plead guilty now and get out for time served. Or they can challenge this charge and stay in jail for another couple months. Most everybody takes that deal, right? Because even if you have a good defense, you don't want to stay in jail for a few months to challenge the charge. And so I think that the requirement of bond is way overused. For folks who are arrested and charged for misdemeanor offenses and for nonviolent offenses of most any kind, shouldn't have to come up with money before they've even had a chance to challenge the charges against them to be out of jail. It's just, wealthy people don't have to do that, right? Wealthy people are out of jail. And so it's poorer folks who have to sit in jail before trial. And that you end up with a very different dynamic that you can't work with your lawyer to defend yourself. There's pressure to plead guilty, to get out sooner, all that stuff. So I'm running to bring in some of these reforms so that we end up with a more just system, so that things that are not really meritorious, not the sort of things that should be in the system, stay out of the system, so that resources can be focused on what's most important. And to recognize that every person, including people who are arrested for something, are equal members of this community and should be treated that way.
Thank you very kindly for both of your wonderful statements. We are now open up to questions, so if anybody has questions for the two candidates, just briefly, when does the Democratic primary open for you guys?
April 24th is the first day of voting, and then, but June 3rd is the date. And so there'll be, for students who want to vote, it'll be about 3 weeks of voting before before everything's done.
Most excellent. And is everybody in this room currently registered to vote in Johnson County? Everyone? Excellent, then have it.
If not, our auditor is great about getting out there and getting people to vote, and or getting people registered and everything, so.
We have voter registration forms right over there, actually.
Very good.
And in Iowa, you can tell your friends, you can register right at the polls. So even if someone is registered out of state or has never registered, they can just show up and do the paperwork.
So you had a question, Andrew?
Yeah, I'm really interested in hearing how you determine what level to set bonds at, a little bit more specifically
Yeah,
between
I can
both of you.
tell you that it's actually not set by the prosecutor or the police, it's set by the judge.
Okay.
And so what the judge does is every morning, and if you want to go watch, it's pretty interesting. The judge at 8 in the morning or 8:15, 8:30, depending on what time the judge gets there, because the judge gets to decide when they're going to get there, usually between 8:15 and 8:30. They'll see everybody who's been arrested overnight, and they will determine the conditions of release. Most people get released on ROR, we call it, or released on their own recognizance, which is their promise to appear. The judge then looks at what are their ties to the community, what's the likelihood that they're going to show up again, looks at their past criminal record. So maybe this isn't a more serious offense, but this person's been in, 5 times in the last year, and clearly they're not getting the message, and so they might put a higher bond on them or put a bond on them. They could also be released to supervision to the Department of Correctional Services, and so that may be somebody who has committed maybe a more serious offense, but they have ties to the community, they have a job, they have a family, and so the judge thinks they're gonna show up for everything, but really feels like they need to check in on them. We often do that with our people who have maybe some mental health problems, so we get them hooked up with services and then release them under supervision so that we can keep track and make sure they're making their appointments and following up on things that they need to do. But it's totally the discretion of the judge. We can go in and make recommendations, but the judge decides that. Something we have in Johnson County too is that we implemented, 8 years ago or something, what we call our informal bond reviews. So every day by 4 o'clock, a defense attorney can come in and sign up to have an informal bond review hearing the next morning. So if they have somebody arrested today and tomorrow morning the judge puts $1,000 bond on them and they can't post that, their attorney can request tomorrow afternoon to have a bond review hearing, and that would be held on Thursday morning at 8 a.m. Somebody from my office is there, somebody from the Department of Correctional Services, again, that's probation and parole, who will make recommendations to the judge about whether they be released or not. I have to tell you, frequently I go to those and I don't have to say anything because it's real clear that this person can get out, or it's real clear that this person has such a bad record or what they're charged with is so serious that you don't want them out on the street. But that allows us to get people out very quickly. If they don't get out at an informal bond review, that's what I'm saying. We look over everybody who's in jail once a week to see if it seems like somebody's been sitting in there for maybe not that serious of an offense. And then we can make the recommendation right to the judge right there saying, hey, the state doesn't, we don't need a bond on them. You can let them out. Well, I think there are places where it's like you can plead and get out, and sometimes certainly it's like we make a plea offer and say, look, we're only looking for, 5 days in jail, and now your client's been in there for 5 days. It's kind of like, are they gonna plead guilty eventually? And what is inevitably frustrating for prosecutors, we say, we want them to do their 2 days and their OWI or whatever it is, which is the mandatory minimum, and the defense attorney doesn't do anything, and the person sits in there for longer. We're kind of like, look, they need to get out. And so actually having those weekly meetings is a good chance for us to kind of say, look, they've done all the time we want. To the judge, let them out, even if their attorney isn't doing that for them. So that's kind of how it's set. The judge makes those decisions. In some counties, in some states, the prosecutor goes to the initial appearances and makes a recommendation about what the bond conditions should be. I've chosen we don't do that in Johnson County because, one, the judge is going to do what they're going to do anyhow, and two, we don't have the staff to do it, so I would have to have somebody sitting up in the courtroom for about an hour every morning. Sometimes I do have some staff go up there just because I want to find out what's going on with different cases or things like that. But the judge, I have to tell you, I've been in front of enough judges, and I can tell you our judges are going to do what they want to do regardless of what I say on bond conditions initially. And so that's how it works, though. So I should tell you, backing up a little bit, when somebody is charged with an offense, there's usually a set amount of a bond that goes with that. So if somebody's charged with something, there is a set amount, and if they get arrested for it, and whatever that amount is, they can pay it between when they get arrested and their initial appearance in the morning. So if they get arrested at midnight and the set bond is, $200 or whatever it is, if they post that at the jail, then they can get out, and then they just have to show back up at 8 in the morning for their initial appearance. So that can happen, and certainly that would affect people who don't have a lot of money, because they're not gonna be able to post it, they're gonna have to spend the night in jail before they appear before the judge. The other thing we've done within Johnson County is try to make sure everybody has an application for court-appointed counsel if they can't afford one before their initial appearance, and have somebody from the public defender's office appointed for them right away. And there's somebody actually from the public defender's office assigned to meet with people in the jail, so they can get them signed up right away, figure out if they need to get their bond conditions released, but to try to work with them to try to figure out what they need to do on conditions of release.
So a few things. If I am elected, we will have somebody at those hearings in the morning. And so the judge doesn't just go by the recommendation of the Department of Corrections. I mean, the criteria that Department of Corrections uses, like the county attorney has said, includes things like ties to the community, stability of residence, do you have a job? So if you're poor, if you haven't lived here too long, if you kind of bounce around, you're going to come up bad. And so in some ways, the poorer you are, the higher your bond is. And so that's not a very good system, I don't think. And so if I'm elected, we will have a prosecutor there making our recommendation. I was asking, Rock Nicole is supporting me, he's a defense attorney in town, and I asked him if he has ever seen a prosecutor recommend somebody be released of their own recognizance and the judge refused to do it. He said no. Now, maybe it's happened, but it's not going to be very often, right? And so judges go by their schedule, but if there's, in the adversarial system, if the prosecutor says don't hold them, it's very unlikely the person is going to be held. I ran the numbers a day ago on the people who were in the jail. This is the middle of the day on, it was like Saturday or Sunday. And so I came up with 114 people in jail. 19 of them, which is 17%, were there on misdemeanor charges, which can range from anything. I mean, some of them were violent, some of them were nonviolent. 24 of them, 21%, were there for nonviolent felonies. So drug crimes and theft, pretty much. A couple forgeries. And then there were 10 people there for OWIs who were in jail, and 6 people there on probation violations, and so I couldn't tell what those were. But just to say, just take 24 people there for nonviolent felonies, drug charges, theft charges, right? The county attorney was saying, these people haven't learned their lesson. These are people who have not been convicted, right? They've only been arrested. Just because a cop decides to arrest you does not mean the state can prove its case against you. And if you have money, the state has to prove its case. You don't do jail based on a police officer's decision. You don't have punishment before trial if you have money. But if you're poor, the assumption is, oh, well, if a cop made an arrest, you must be legally guilty. And so that is not how it is if you're wealthy, and we shouldn't have 2 criminal justice systems. And so, there is a bond schedule and recommendations from the Department of Corrections. Oh, actually, another point related to this. So hasn't gotten a lot of press, but there is currently a financial scandal going on in the local Department of Corrections, the 6th Judicial District. There was apparently a lot of money that was former employees, so former, probation and parole officers, formed a nonprofit. That money was then being funneled, they were contracted from the Judicial District, which makes these recommendations, handles probation and parole, to former employees who were actually getting paid more than the people who are actually doing the main job. So it was a way, to kind of double their size and funnel money to former workers. And the state auditor is investigating, and there's an investigation that may lead to criminal charges. So anyway, one interesting thing about that is there were minutes from one of the meetings that were published in the auditor's report, and the question was from one of the board members. So why is there a budget shortage? And they said the answer was, we don't have enough people in the system right now. Okay, so there is a financial incentive for the people who make the bond recommendations to finance their jobs to make high recommendations. right? So that people are in the system, to keep people on probation and parole, for different kinds of supervision, and so it's not an unbiased system, right? And if and a prosecutor can choose to use that to squeeze people, or a prosecutor can be committed to, which is the only elected person in this whole process, to work toward a system in which people with less money get treated like people with more money. And that's a decision that the prosecutor has to make, and including the presumption of innocence, which you have not heard the county attorney talk very much about. Kind of the assumption seems to be that everybody who gets arrested is legally guilty. So if I'm elected, if I'm arrested, I will bond out of jail and fight the charge. If I'm elected, we will have a county attorney office, including all the prosecutors, who will be told, and it will be emphasized, that part of our job is to make sure that people get treated fairly, with due process, with a chance to defend themselves, no matter what their financial resources are.